Hi everyone, this video is about the Indian citizenship. In this presentation, I am going to analyze the provisions of the Indian Constitution relating to citizenship. In a separate video, I am going to discuss the provisions of the Citizenship Act of 1955, which deals with the acquisition and termination of citizenship after the commencement of the Constitution. The conferment of a person as a citizen of India is governed by the Part 2 of the Constitution of India. The term citizenship refers to the enjoyment of the full membership of any community or state in which a citizen enjoys civil and political rights. The citizenship can be defined as a legal relationship of an individual with a particular state. It is a membership in a political community which is largely coterminous with the nationality. In India, Article 5 to 11 of the Constitution lay down who are the citizens of India at the commencement of the Constitution. And the Citizenship Act of 1955, a parliamentary law, deals with the acquisition of citizenship after 26th January 1950. The Constitution contemplates three classes of citizens. One, citizens by domicile, citizens by migration, citizens by registration. Article 5 lays down who is a citizen by domicile. According to it, every person having domicile at the commencement of the Constitution and who fulfills any of the following conditions could become citizen by domicile. They are: he was born in India, or either of whose parents was born in India, or who had been ordinarily resident in the territory of India for not less than 5 years immediately before 26th Jan 1950. Then let us know what is domicile. The basic idea is permanent residence, where one resides with the intention of remaining there. Mere residence is not sufficient. There must be an intention to reside permanently. Thus, in Louis the Rate versus Union of India, this issue was considered by the Supreme Court. In this case, a foreigner had been living in India for 30 years since 1937. He was staying in India on the basis of a foreign passport with the permission of the Indian authorities. There is nothing to suggest that he intended to permanently reside in India. He claimed citizenship under Clause C of Article 5. The Supreme Court rejected his claim as he could not prove his intention to permanently reside in India. It was held that mere residence is not sufficient to claim the citizen. In India, a minor takes the domicile of his father and a married woman acquires her husband's domicile. The conditions in clauses A, B, C of Article 5 are not cumulative but alternative. That means a person to acquire citizenship under Article 5 has to satisfy any of the conditions and not all the conditions. Article 6 deals with the acquisition of citizenship by migration from Pakistan. Just after independence, there was large-scale migration of people from Pakistan, that is, the territory which had ceased to be part of India. They could not be considered as citizens under Article 5, so Article 6 makes a special provision for them. Persons who migrated from Pakistan to India fall into two categories under Article 6. The first category includes those persons who came before 19 July 1948, and if he or either of his parents or any of his grandparents was born in India prior to the independence under the Government of India Act of 1935. And secondly, if he had been ordinarily resident in India since the date of his migration. The second category includes persons who came on or after 19th July 1948 if he or either of his parents or any of his grandparents was born in India under the Government of India Act of 1935, and such a migrant must make an application for citizenship. Further, he must prove that he has resided in India for at least 6 months, and he must be registered as a citizen of India by an officer appointed by the Government of India. The significance of 19th July 1948 is that the West Pakistan Control Ordinance 1948 was issued, which established a system of permits and became effective from 19th July 1948, and it introduced the system of registration. Article 8 deals with the third category of citizens. According to Article 8, a person who or either of whose parents or any of whose grandparents was born in India, that is before independence, but who is ordinarily residing in any country outside India and Pakistan may register himself as a citizen of India with the diplomatic or consular representative of India in the country of residence. This provision confers citizenship on a person who prima facie has no domicile in India, and it covers overseas Indians who may desire to acquire Indian citizenship. Article 7 deals with the termination of citizenship. According to this provision, a citizen of India by domicile under Article 5 or by migration under Article 6 ceases to be a citizen if he has migrated to Pakistan after 1st March 1947. If he, however, after migration to Pakistan returned under a permit of resettlement or permanent return, he can register as a citizen of India in the same manner as a person migrating from Pakistan after July 19, 1948. Thus, Article 7 overrides Article 5 and 6 and envisages only those persons who migrated to Pakistan between March 1st, 1947 and January 26, 1950, and they lose their citizenship. Thus, in the state of Bihar versus Kumar Amar Singh, the Supreme Court held that if the wife was born and domiciled in India goes to Pakistan after March 1st, 1947, leaving her husband in India would lose her citizenship. Article 7 was held to be peremptory and admits no exception in this regard. Article 9 deals with dual citizenship. According to this provision, no person can be a citizen of India under Article 5, 6 and 8 if he has voluntarily acquired the citizenship of a foreign country. This provision thus recognizes the principle that no Indian citizen can claim a dual or plural citizenship. However, this is subject to Parliament's power under Article 11 to provide for the acquisition of citizenship. Thus, Article 9 applies only to those cases where foreign citizenship had been acquired before and not after the commencement of the Constitution. The Indian Citizenship Act of 1955 deals with the latter type of situation. Article 10 provides that every citizen of India under Articles 5 to 8 shall, subject to law made by the Parliament, continue to be such a citizen. Thus, a law enacted by the Parliament, changes can be made in citizenship acquired under Articles 5 to 8. Under Article 11, Parliament has been empowered to make law with respect to citizenship, naturalization and aliens. The Parliament has enacted the Citizenship Act of 1955, and this act deals with the acquisition of citizenship after 26th January 1950. The act makes necessary provisions for the acquisition, termination and deprivation of citizenship in certain circumstances. A detailed analysis of the provisions of the Citizenship Act has been made separately in another video in this channel as a part 2. Thank you for your patient listening.